Be ready. Start. Heard Sri Rajesh Tandon appearing for the petitioner and Kumari Anu Jaiswal appearing for the respondent number 2. Kumari Anu Jaiswal gives a statement that she does not intend to file any counter affidavit and this writ petition may be heard and disposed of finally with the consent of parties, counsel, and in the circumstances of the case, this writ petition is disposed of finally. Para. Respondent number 3 and 4 filed suit for rent and ejectment against the petitioner on the ground of default of payment of rent, alleging therein that the defendant petitioner was in arrears of rent from 1st October 87 which remain unpaid despite service of notice of demand on 6th September 1993. The petitioner contested the suit alleging that no amount of rent was due as he had paid entire rent to the plaintiff, but no receipt was issued. Therefore, the trial court did not accept this assertion of the tenant about the payment of rent to the landlords and recorded a finding that the defendant petitioner was a defaulter. The trial court, however, decreed suit for arrears of rent only and dismissed the same for ejectment on the ground that notice of demand and termination was not proved to have been duly served upon the petitioner. Against the judgment of the trial court, the landlord's preferred revision, which has been allowed by the impugned order, and the plaintiff's suit has been decreed in toto. Para. Learned counsel for the tenant petitioner argued before me that the revision court has acted beyond its powers in making interference in the finding of fact recorded by the trial court regarding service of notice, which was based upon appraisal of evidence. He argued that it was found by the trial court that it was not fully established that the notice of demand and termination was tendered to the tenant and the same was refused by him. This finding of the trial court has been reversed by the revision court on the ground that the evidence was not properly assessed and appreciated by the trial court. Para. The position with regard to the scope of powers of the court hearing revisions under section 25 of the Provincial Small Causes Court is well settled. Such powers are only supervisory and the revision court has not been invested with the powers which are possessed by appellate court as far as the matter of appreciation of evidence is concerned. The revision court has a limited jurisdiction to examine the legality of the decree passed by the trial court. It has no power to examine the evidence of the case in order to decide whether or not the finding of fact recorded by the trial court is justified or not, nor the revisional court can substitute its own finding of fact for the one recorded by the trial court if certain piece of evidence and material has been not taken into consideration by the trial court, which in the opinion of the revision court was necessary. The appropriate course in such a situation is to send the case back to the trial court for a fresh decision in the light of guidelines which may be indicated by the revisional court in its judgment. In this connection, a reference may be made to the division bench case of this court in Lakshmi Kishore and another versus Har Prasad Shukla and others 1981 ARC 545 Durga Prasad and others with 7th Additional District Judge Kanpur Nagar and others 1998 AWC 1161 Jaydev Mishra versus District Judge Faizabad and others 1998 ARC 354 and the decision in writ petition number 6505 of 1980 Kailash Chandra and another versus third additional judge Jalon Orai and others decided on 25th August 1998. Stop.